Administration is an insolvency procedure for companies in the United Kingdom. A company can be placed in administration by court order, by appointment by a qualifying floating charge holder, or by the directors or shareholders of a company. When an administrator is appointed, the directors of the company will cease to be able to exercise their management powers, but will continue to be subject to their fiduciary duties to the company. When an administrator is appointed, he will give a statement of the purpose of the administration to the court. The primary purpose of administration is to save a company as a going concern. If that cannot be achieved in the particular circumstances, the administrator will look to achieve a better result for the creditors than would be possible through a liquidation. What the administrator will actually do in practice will depend upon whether the administration is a standard administration or a pre-pack administration. In a standard administration, assuming that the administrator takes the view that the company cannot be saved, he will look to trade the business of the company for a limited period after being appointed, with a view to marketing it for sale at the best price achievable. Upon his appointment, he will usually look to streamline the business, which will result in the summary dismissal of a large portion of the company's employees. There will usually be a period of several weeks between the appointment taking effect and the business of the company being sold. Understandably, this will result in a high level of disruption to the customers, suppliers and employees. The key distinction between what I've just described and a pre-pack administration is that under a pre-pack administration, a deal has already been agreed and concluded before the administrator is appointed. There are two general points that any buyer needs to bear in mind when contemplating purchasing the assets of a company in administration. The first one is that the selling company will not give any warranties or indemnities, such that in return for the price which is paid, the seller will only agree to transfer such right, title and interest as it has in the assets which it purports to sell. The second point is that the administrator will also require that certain indemnities be given by the buyer in favour of the seller and also the administrator as an individual. Although both of these features will always appear in a transaction with an administrator, it should not be thought that a contract put forward by the administrator's solicitors is not capable of being amended. The contract will need to be carefully reviewed by the buyer's solicitors. Everyman Legal would not typically act for an insolvency practitioner who has been appointed as administrator. Our role would be to act for the buyer of the business and also the directors of the company, who would usually require quite a high level of support with the overall process and also advice in connection with their fiduciary duties.